thanks to all of our witnesses. And again, just sounds like we have some technical issues with Hen Brooks, so we'll try to bring him back in the second panel. I did have a few questions I wanted to ask, and then I'll turn to my colleagues. When I look at this, there are areas of agreement, there's areas of disagreement, right? So I think there's a chorus of voices actually that say, we need to make change. I'm one of those and believe that that's what we have in front of us. As I look at the bills that are the two bills that are officially a part of this hearing, and then of course we're going to talk about the Restore Act as well, even though it's not officially a part of the hearing. Both of those deal with sealing, and even though one actually has the word expungement in the title of it, actually it does nothing about expungement, it's only sealing. And then of course we have issues around expungement. There are disagreements about, and so there's a chorus that I think says we need to make change and make reform. And then the agreement kind of diverts from there. We've got proposals that are sealing only. We have proposals that are sealing and expungement. We have time periods that remain. We have time periods that would be reduced, time periods that would be eliminated. We have automatic sealing. We have some that don't have automatic sealing. We have expansion of eligibility. We have others that don't, that change in some degree, some that change more narrowly. So for me, at least, that's what I believe the committee's role here is to say, how do we move quickly with urgency, but also where do we help bring the different proposals and different ideas to come together to be able to move something forward. And that's part of the challenge that we have. I wanted to ask if I can and maybe I'll start, certainly I want to ask Mr. Jeffress this, Ms. Love, Ms. Sultan, Ms. Akintoya. Let me ask this about the waiting periods. What's the point of a waiting period? Like, if I take a look at both my flow charts of exactly how this works right now, for my arrests or charges or no paper decisions, current law, there's still a 2-year waiting period. If I got arrested and then everything was dropped, like nothing moved forward after that, I still have to wait 2 years. And then of course, if I have a conviction, then there's much longer waiting periods. What's the point of a waiting period? Can you help explain from your perspective, why is there even a waiting period at all? What's the purpose? Even if I have had a conviction and have completed my sentence, what's the point of a waiting period? And I'll open that up to everybody, of course, but I think I heard a few of our panelists kind of touch on this and wanted to ask them directly.
Well, I can just speak to the experience of other jurisdictions. I think that it's really important to distinguish between non-conviction records and conviction records. That's one area that DC is really different from other jurisdictions. Almost every jurisdiction has a specific provision for sealing non-conviction records, and about half the states do it immediately and automatically. So if the case has not been made against someone, that record, there's no reason for there to be any waiting period at all in those cases. When you get to convictions, it becomes a little bit different because you're looking at different issues of what are you trying to show. And I think it's a little bit of a misnomer to get too stuck on the difference between sealing and expungement. These are not terms of art, as the lawyers say. Jurisdictions use these terms interchangeably. So you're really talking about what kind of functional limits do you want to put on public access? Who should have access? Who should have limited access? This sort of stuff. But don't, my suggestion is don't get too stuck on the terminology. The one thing that I really would say is please distinguish between non-convictions and convictions. That's really an important first step.
Okay, thanks. Ms. Sultan, you want to jump in?
Sure. So first I want to note that I don't think there's as much divergence as you may have thought. So when we look at the language of the Restore Act, it actually does incorporate almost all of the things that you've heard about today, right? So it addresses the simplification, it addresses getting rid of disqualifying arrests and convictions. I think it addresses all of the concerns and that the only way to really do that is to change Chapter 8. The other two bills don't solve any of the problems that we heard about. For example, the disqualifying arrests and convictions that are so unusual for non-convictions that other jurisdictions don't have is not solved by the mayor's bill or by the second bill. So I'm hopeful that it actually does address all of the things that you mentioned. When you ask about the purpose of the waiting period, the Restore Act has different waiting periods for misdemeanors, felonies, and crimes of violence. The real purpose of that, I think, is if you read it in conjunction with sort of the language about how somebody would go about repetitioning, it prevents someone from filing a new motion every single month on end and sort of like lays out, how long someone will have to wait before they can file. The current scheme and the proposed bills that you have today make it really, really difficult for the court to assess eligibility because it calculates the waiting period based on when the person is completely off papers. And that's not information that the court has readily available. CSOSA knows when somebody got off probation, but unless they communicate that to the court doesn't know. So it's really, really hard to administer. What the Restore Act does is it says calculate it from the time that the person was convicted. And if they're still under sentence, they have to wait until they complete that sentence before they can apply. And it's just a much cleaner system. They can automatically set a timer, so to speak, on the record when the person is convicted and be able to tell the moment someone's eligible for criminal record sealing. Our definition of crime of violence in DC needs a little bit of work, needs some refining, but I think that's kind of an issue for another day. But that was the idea of sort of staggering those terms and making them considerably shorter and tethered to something that's easier to measure.
Okay, thank you. I definitely want to hear from Mr. Jefferson, Ms. Akintoya as well.
Yeah, I would just reiterate what Ms. Love and Ms. Sultan said, and looking at the approaches on the timing, I do agree with Ms. Sultan that is by far the most easily administered approach and one that makes the most sense in terms of, you want finality, but at the same time, you want a workable system that makes sense in terms of what the sentence was. So I would just reiterate that.
Thank you.
Yeah, and to jump in as well, this is Hannah Akintoya here. I think the purpose of the waiting period also is for the courts or for anybody to kind of ascertain whether or not this person is going to either get arrested again. And then if they do get arrested again, or let's say they do get convicted again, now they fall under these disqualifying arrests. So now they fall under these disqualifying convictions. And now it makes it a little bit harder for this individual to go ahead and seal a particular arrest. And even if they got, let's say they have a disqualifying arrest or a disqualifying conviction, after the one that they may want to seal, it has nothing to do with the particular offense that they want to seal. And so now you have a disqualifying arrest, you have a disqualifying conviction, according to the current statute, and it essentially makes it a little bit difficult, a little bit more difficult for you to now get your record sealed. So I think that, as the Restore Act does propose, just making it a little bit more concise makes a little bit more sense. All these waiting periods, they are quite difficult to understand, and it just needs to be simplified.
Yeah, and then I have one follow-up question, and then Councilmember Henderson, I'll turn to you. And that was, I am in agreement that, especially when we talk about an arrest, no paper, no conviction, that should move into an automatic. We shouldn't be having waiting periods for that. Is there ever, when we have the government panel, I'll certainly ask USAO this question, but are there going to be situations you think where, from a prosecution standpoint, there may be an arrest, but they decide that they're waiting to either paper the case, perhaps it's got a grand jury, other reasons why there may be a reason not to? And if that's the case, do you believe that by giving prosecution the opportunity to petition is the right way to help resolve that issue where there may be, an action yet to come from a prosecution on that certain arrest?
Yes, I think that's a really important consideration, not only whether prosecution needs it for an open investigation, but also if there's relevant information in that file that pertains to another case, right? So police said in one instance that the person who resides in bedroom A was Mr. Smith, and then in a new case, they've charged Ms. Jones with something found in bedroom A. They have to turn over that information about the earlier investigation, if that makes sense. So with respect to expungement, what we're saying is that the court would just have those files sequestered in a non-public file. If the government needs access to that, they have to petition the court and ask them for it. And they can do that if there's a lawful purpose for doing that. For those things that are sealed and automatically sealed, law enforcement and prosecutors would still have access to those records. They would just have to keep them in a non-public file and report that they don't have anything if somebody from outside the office asks about it. So they're still able to use that for purposes of their investigation. They're still able to use it if they need to ask the court permission to turn it over to somebody else in another case. So I don't think it hinders them very much. And I think that's why so many other jurisdictions do it this way.
Yeah. Okay. Thank you. Let me turn to Councilor Henderson now.
Thank you, Chairperson Allen, and I want to thank everyone for their testimonies. I kind of want to back up a little bit. I've been reading The Sum of Us by Heather McGhee, and I think it's important as we go through these processes of reforming the criminal justice system that we provide additional context for people in terms of how we got here and why we need to sort of reverse course. And Ms. Love, you were talking about how DC's current record sealing law is one of the most complex and restrictive in the country, and that while other jurisdictions have moved to change, we haven't. Why do you think that is?
Well, I'm not sure why. It's a very, very complex law. It's true that I do this almost every day looking at statutes, and boy, I'll tell you, it takes a long time to figure out what the DC law provides. I don't know why it's so complex. It really is. And I don't know why it's so restrictive. And the kind of confusion between conviction and non-conviction records is really unique. And one thing that I've been sitting here thinking I really wanted to mention, I really hope the committee will look at the whole issue of diversionary dispositions and the role of the court in managing deferred adjudication. Under DC's present law, the government has all the cards and all the control. And I'm just thinking that perhaps the committee ought to look, many, many states are developing deferred dispositions that steer people out of the system, give them a second chance. Maybe they don't want to dismiss the charges entirely, but give them a chance to show that they can do well under supervision and then dismiss the charges. So I can't explain why DC law is so complicated. It really is. Believe me, it is really complicated. And it is also restricted. So you all have a tremendous opportunity to straighten this out. And Virginia has just done it. And a lot of states have done it, really ones that you might think are surprising to compare yourself to, like Indiana, like North Dakota. It's a strange landscape out there, believe me, and it's not a red and blue issue. Anyway, I'm very excited that you're undertaking this really important issue of record relief. I actually look forward to seeing what the government says.
Thank you.
And also perhaps add a little bit of insight. The Council for Court Excellence was actually the organizing body of the working group that developed the law that we have now about a decade ago. And I think part of the reason it's as complicated as it is because we had lots of stakeholders with lots of perspectives at the table, and it was a real compromise bill. But also because we were starting from zero. We were one of the last jurisdictions in the country who had nothing before then. Before 10 years ago, we had no record sealing, no expungement, nothing at all. And so this was really just a very first initial step. And I think there's a lot of room to grow on what we know and have learned.
Yeah. I wanted to ask you actually, Ms. Taro, a question. You were talking about in your testimony, I guess the need for researchers to be able to access data. Can you speak to a little bit more on that? Because I'm not sure that any of the bills under consideration go this far.
Yeah, this is something that had came up at the recent hearing on eviction record sealing. And actually we had at the last hearing on a similar set of bills back in 2017, there were people from Open Government Coalition and from a couple of different journalism organizations that testified, where you can probably find some more detail in the record. But there is a purpose to looking at records. We wouldn't know how disproportionately Black people were impacted by our justice system if we weren't able to look at the records. We wouldn't be able to say, oh, these are how many cases are getting dropped. These are how many cases are reaching conviction. This is how long people are being sentenced if we couldn't look at court records. So we just want to be careful and balanced when we are sealing or expunging to make sure that we are leaving de-identified records, right? Not things that can be tied to a person's name in public, but things that we can look at to study and to understand our system better.
Ms. Akintoya, I was practicing and I butchered it. I'm so sorry.
Okay, it's Akintoya.
Akintoya. The way that, I think one of the interests I've always had in terms of the record sealing is that in terms of my conversations with folks, the way that our current system now, it's almost impossible for someone to really be successful in a record sealing motion if they didn't have an attorney. Is that your experience? Because I imagine some of the clients who come to you, it's after they're at their wits' ends at that point. And I know that at the courthouse, the clerk who you're talking to at the desk can't necessarily say, hey, you might want to call a lawyer for this, right? They can't provide that particular level of legal advice. But I'm curious if you could speak to when your clients get to you, how much have they had tried before and failed?
Yeah, that's a really good, interesting point that you made. But so traditionally, what has been happening in DC, in the district, was that the Public Defender Service was providing a lot of free advice and guidance for record sealing. But since the pandemic, what has happened is that there has been this surge, this flood of people needing record sealings because of the jobs right now that are available, and the whole crisis that's happening right now. People are not able to get jobs either, or they're getting fired or they're getting laid off, and now they're applying for new positions, and now they're realizing that their record is actually affecting them from moving forward or even just getting a basic job. And so what ended up happening, as far as my understanding, is that because the Public Defender Service was just so flooded, they had to stop providing guidance on record sealing right now. And so now that there's nowhere to go, people now are forced to find attorneys to help them. And it's hard to be in a position where you don't have a job, and you don't have money coming in, but then in order to get that job, you need to spend more money, i.e. hire an attorney to help you seal their record. So yes, a lot of the people who do come to me, for instance, to seal their record have, they've gone online, they've consulted Attorney Google, and they've consulted all these blogs and databases, and then they just so happen to maybe come across my website or come across something that they may have seen out there on the internet, and they're saying, oh, okay, well, this person may be able to help me. But they're still having trouble getting to that place. They still try to do it on their own first, and they still try to exhaust those options first before they then go to an attorney. And so usually the attorney is sometimes the last resort, especially for somebody who doesn't want to, spend the money to hire, or retain an attorney. On the other end, there are individuals who already have a great profession, and maybe their job is not affected by them getting arrested, especially if it's something small. And so they know that they want to get this particular record sealed or expunged. And if they have those funds, they're going to want to do it immediately, or they're going to want to inquire immediately to get that particular record sealed or expunged. But I will have to say that the primary effect of the individuals, right, who are not able to at least hire an attorney or retain an attorney or get some type of legal guidance for their specific situation are the individuals who are minorities, who are African Americans, and who don't make that much, right? Who cannot afford to decide, do I feed my children today, or do I retain an attorney so that I can feed my children tomorrow? And I think that's the issue that we are now encountering because of the current job crisis.
Thank you. And Ms. Sultan, I just want to give you an opportunity to clarify, because I feel like sometimes when we get into these conversations about record sealing and expungement, opponents to sort of automatic expungements or these types of processes that are simplified might try to conflate the message in terms of the public around saying, oh, by shortening the waiting period, it allows for criminals, quote unquote, to come back to the streets earlier, or something, to that effect. And can you just explain again that by shortening the waiting time, it doesn't shorten the sentence that someone, if they have a conviction for which they're actually serving their time?
Yes, so the waiting period is the amount of time that a person would have to wait before they can ask the court to seal their record. It is the amount of time we're waiting to give the court the authority to do that. It doesn't bind the court's hands in any way, but what it does is incentivizes a person to build a record based on these factors that it's in the interest of justice to seal the record. And that's a great opportunity and incentive for everyone. And it should be up to judges to decide based on those interests of justice factors and not based simply on the nature of the offense and the amount of time that's lapsed. So it's really just about that sort of capacity for the court to be able to take action. It's not actually forcing the court to do any of that. But I think more importantly, we have to start thinking about the fact that drawing these sort of arbitrary lines about which groups of people should be subjugated based on what they did is so antithetical to what people are saying in other spaces about, you hear Brian Stevenson talk about a person's not the worst thing that they've ever done. And a lot of people embrace that in theory, but then in practice, when we look at our record sealing laws, it really doesn't measure up to that. It says, we try to draw these lines about what if the worst thing you did was really, really bad, then we're not going to give you an opportunity to be able to be made whole. And so I think we should try to rid ourselves of that line drawing habit in a more general sense, but particularly when it comes to record sealing.
Thank you. My time's up. Thank you, Mr. Chairman.
Thank you, Councilmember. I want to thank everybody on this panel. I think, one of the things I appreciate Councilmember Henderson kind of also pulling back a little bit to take a look at it, because I think a large amount of the work that we've been focusing on within this committee is, we think, of the last couple of years of reforming our YRA to be able to be more expansive and include more individuals in those set-asides. Looking at things like our expansion of IRA, looking at things like the collateral consequences legislation that we just passed, which gets at all those barriers. This to me is yet one more of those urgent pieces of fabric or urgent threads that are being woven into the overall fabric of the change that we're making. And so I really appreciate all the testimony and conversations today. So thank you all very much.
Before we move, can I just I think that
very briefly, Commissioner.
Yeah, I think we need to emphasize that the purpose of sealing the record is not to hinder prosecution or the work of the court. That will continue. The purpose of my view from a community person is to help people who have done their who served their time, not convicted or not charged, to be able to move forward with getting a job, getting an apartment, getting whatever, and the sealing will help them for that low-hanging criminal offense, as opposed to targeting for life. Sealing does not impact negatively research by newspapers, the media, or the courts, or the justice system.
Okay. Yep. Thank you. Appreciate that, Commissioner. All right. Well, again, my thanks to this entire panel. Appreciate the testimony, the insight, and look forward to continuing to work with you. So thank you all very much.
Thank you.
We'll move next to